Hello everyone, my name is Alex Grant. Welcome to Immigration Update Desk. As 2026 unfolds, something important is happening in Washington that many immigrants have been waiting years to see. After a long period of gridlock and stop-start debates, Congress has begun approving and advancing a series of immigration-related bills and provisions that directly affect green cards, U.S. visas, and immigrant families. These are not symbolic resolutions or campaign slogans. They are legislative actions moving through committees, floor votes, and negotiated packages that point toward stability, relief, and overdue modernization in the immigration system. In this report, I will explain what kinds of green card and visa measures Congress has passed or moved forward in 2026, what those measures actually change in practical terms, who stands to benefit first, and why this moment brings cautious but real hope for families, employers, and students. If you find this useful, please subscribe to Immigration Update Desk, tap the bell, and like this video so timely updates reach your phone. When Congress acts, details matter, and small timing differences can change when you file and how fast your case can move. To understand why this moment matters, it helps to see both the big picture and the small mechanics. For more than a decade, immigration has been a politically difficult topic, producing a patchwork of rules, memos, and court decisions rather than durable legislation. In the past several months, however, Congress has approved multiple immigration-related bills and broader legislative packages that include targeted provisions aimed at easing family and employment green card backlogs, protecting certain temporary visa holders from harmful gaps caused by government delays, and strengthening the way applications are processed and tracked. Some measures have cleared one chamber and moved to the other. Others were included in omnibus funding or policy packages, which is how Congress often advances complex topics when a single sweeping reform bill is not politically possible. Taken together, these actions reflect a growing recognition on Capitol Hill that the immigration system cannot remain frozen while demand rises, priority dates stall, and families remain separated. One of the most significant themes in the 2026 approvals involves green card availability and backlog relief. Several provisions focus on recapturing or reclaiming immigrant visa numbers that went unused in prior fiscal years because of administrative delays, pandemic shutdowns, or mismatched capacity between agencies. For years, tens of thousands of green cards were left on the table even as families and workers waited in line. When a fiscal year closed, those numbers often vanished instead of flowing to applicants who had already done everything required. The new legislative direction aims to correct that imbalance by allowing unused numbers from past years to be reallocated to people already in the queue, with an emphasis on family-based categories where wait times have stretched into decades for some countries. In practical terms, Recapture does not eliminate lines overnight, but it can push priority dates forward, reduce the number of applicants stuck at the edge of current, and convert theoretical eligibility into actual interviews and approvals. Families with aging children stand to gain from another cluster of approvals, strengthen protections for sons and daughters who risk losing eligibility because of long government processing times. Over the years, the Child Status Protection Act has shielded many children from aging out, but gaps remained, especially where agency delays were significant or where interpretation varied by office. Measures advanced in 2026 seek to lock a child's age more predictably, preserve derivative status when a case moves from one stage to another, and ensure that families do not lose their place simply because the system moved too slowly. In real life, that means a teenager who started a process as a child is less likely to be told to start over as an adult in a much longer line. It also means families can plan school, housing, and travel with more confidence while they wait. Employment-based immigrants are also directly affected by this year's legislative movement. Several bills passed or advanced in 2026 address long-standing issues in employment green card queues, especially for high-skilled workers who have maintained temporary status for years while contributing to U.S. companies, universities, and hospitals. By improving how visa numbers are counted and carried forward, and by clarifying when unused employment numbers can supplement family categories or vice versa, Congress is taking steps to reduce uncertainty for workers whose lives and careers have been stuck in annual cycles of guesswork. Some provisions focus on stability during processing, such as preserving work authorization and status for employees whose adjustment applications are pending when agencies experience delays. Others reinforce portability rules, so workers can change jobs after a set period without resetting the entire process, which aligns immigration rules with modern labor realities and helps employers retain talent without trapping people in one role out of fear. Temporary visa stability is another area where Congress has acted. Approved measures strengthen safeguards for visa holders facing delays caused by government backlogs, allowing them to remain lawfully employed and present in the United States while waiting for final decisions. Think of H-1B professionals caught between extensions and consular appointments, L-1 transferees whose renewals intersect with slow USCIS cycles, or students on OPT and STEM OPT whose employment authorization hinges on precise filing windows. The driving idea is simple. If government processing is the bottleneck, families should not bear the entire cost of the wait in the form of lost paychecks, broken leases, or school withdrawals. The legislation signals that continuity matters and that lawful presence and work should be preserved when people have done their part correctly. Processing reform runs through many of the 2026 provisions. Congress has authorized funding and directives for modernization in 3 layers: technology, staffing, and accountability. On technology, agencies are being pushed to complete end-to-end digital filing and adjudication, so applications are not repeatedly scanned, printed, and re-scanned through the life of a case. On staffing, appropriations and hiring flexibilities are meant to reduce vacancy rates at service centers, field offices, and consular posts. On accountability, agencies are being asked to publish timelier metrics, identify bottlenecks, and implement surge capacity when lines get out of balance. None of this flips a switch. Building secure digital systems and training adjudicators takes time. But the direction is notable because it treats processing delays as harmful, not merely inconvenient, and it funds solutions rather than pretending time will fix itself. It is important to be honest about limits. The approvals we are describing do not instantly clear all backlogs. They do not deliver immediate green cards to everyone waiting. They do not remove the need for more reforms in the future. What they do is move the system forward in measurable ways, reclaiming lost numbers so they help real families, protecting people from losing eligibility because of government delay, and building capacity so the same problems don't simply reappear next year. For immigrants, this moment offers a different kind of hope. It is not hype. It is not a campaign promise. It is progress written into legislative text and backed by votes, oversight, and budgets. The politics behind these approvals also matter. Immigration has long been one of the most divisive issues in Congress, often stalled by all-or-nothing demands. The fact that lawmakers were able to approve and advance multiple immigration-related bills in 2026 suggests a shift toward pragmatism. Instead of waiting for a single, sweeping overhaul, Congress is using narrower measures to fix concrete problems whose solutions enjoy broader support. This approach treats immigration not just as a talking point, but as an essential system that must function for families, schools, and employers. It also lowers the political temperature, because votes on targeted relief are often easier to build than votes on comprehensive reforms that include dozens of controversial items at once. What does this look like for families abroad? In many cases, the first signs will be modest but meaningful. Priority dates inch forward a few weeks at a time. National visa center queues shrink for specific categories, and consulates begin scheduling interviews for cases that had been documentarily qualified but stuck without numbers. When visa recapture takes effect, applicants close to current are the first to notice because a small movement tips them into interview scheduling. Families should make sure passports will be valid through the interview window, that civil documents match the reciprocity table for their country, and that police certificates are current but not so early that they expire before the appointment. When the bulletin months begin to reflect recaptured numbers, being ready means you do not lose a slot to a missing document. For families inside the United States, the benefits show up as stability and predictability. If your status depends on a pending adjustment or a long extension cycle, measures that protect work authorization during government delays translate into uninterrupted paychecks, health insurance, and school enrollment. If your child is close to aging out, stronger protections mean you can plan college or career moves without fearing that a birthday will undo years of waiting. If you are an employer, the ability to retain talent through portability and continuity provisions reduces turnover and the cost of rehiring, and it encourages investment in training because employees can grow into roles without fearing forced exits. Workers living year after year on temporary visas are seeing something else in 2026's legislative activity: recognition. Congressional actions this year acknowledge that it is not sustainable to rely on a large cohort of high-skilled employees without giving them a clear, durable path forward. That acknowledgement does not guarantee immediate green cards, but it does translate into clearer counting rules, stronger continuity during processing, and a fairer alignment between the contributions workers make and the security they need to build lives. Companies that depend on this talent should be preparing internal policies accordingly. Document roles precisely, match wages to duties and market standards, and plan headcount with an eye toward upcoming visa number availability that Recapture may unlock. Timing is its own story. Even after Congress approves provisions, agencies must issue guidance, update procedures, reprogram systems, and train officers. That takes months. Some changes can start quickly because they rely on simple counting logic or existing pipelines. Others take longer because they require new software releases or hiring. The practical lesson is to watch for agency implementation memos and operational guidance. When USCIS, the Department of State, or the Department of Labor publishes instructions, the window to act opens. Submitting a well-prepared application in the first wave of a new rule can save months compared with waiting for the rush after everyone hears the news. Because big moments attract misinformation, it is worth talking about expectations. Some headlines will overstate what has been approved, promising instant approvals or across-the-board amnesties. Others will dismiss everything as meaningless. The truth is usually in the middle. Congress has not passed a single comprehensive reform that changes every rule at once. It has passed and advanced meaningful pieces that, taken together, move the system forward. The right move for immigrants is to stay informed through primary sources and trusted analysis, keep your case updated, and prepare for opportunities as provisions take effect. Do not abandon pending applications out of frustration, and do not wait for perfect certainty before organizing documents you know you will need. Momentum favors the prepared. To make this concrete, imagine a few realistic scenarios. A U.S. citizen in California filed an I-130 for a married son in the Philippines a decade ago. With recaptured family numbers, the F3 category sees small but steady forward movement. The family checks the new visa bulletin every month, confirms which chart USCIS is using for adjustment filings inside the U.S., and keeps civil documents ready. When the priority date becomes current on Chart A, They already have updated police certificates and valid passports, so their interview is scheduled quickly. In another case, a software engineer on H-1B with an approved I-140 has an I-485 pending. Thanks to continuity provisions tied to processing delays, her work authorization remains valid without last-minute gaps, and after a set period, she can change employers under portability rules without resetting the process. A third example involves a family where a child is turning 21. Strengthened age-out protections mean the child's CSPA calculation locks in time, preserving eligibility as a derivative so the entire family can complete the journey together rather than splitting into separate queues. What about people whose cases are not close to current? Preparation still matters. Keep a clean file that mirrors exactly what you have told agencies in the past. When legislation changes counting rules, people with consistent, well-organized records are first to benefit because their cases do not get sidetracked by avoidable RFEs. If you are at the National Visa Center, check that each document is clear and correctly labeled, and that translations meet the standard. If you are adjusting status, watch for medical exam timing, so your I-693 will still be valid at interview. If your sponsor's income fluctuates, plan for a joint sponsor early, rather than scrambling 2 days before an interview. Each of these steps is boring but powerful because it converts an opportunity into an approval without delay. There are edge cases, and 2026's legislative movement touches them as well. Diversity visa winners worry that administrative delays could cause them to lose visas at the end of the fiscal year. Any recapture and processing efficiency measures designed for broader immigration can reduce pressure on end-of-year bottlenecks. Religious workers and special immigrant categories that see periodic lapses may benefit from carry-forward rules that smooth out gaps between authorizations. Humanitarian pathways, refugee admissions, certain parole programs are affected indirectly when consular staffing and digital upgrades improve throughput across all case types. Even FOIA processing, often overlooked, is slated for modernization in some plans, which helps families obtain old records needed to resolve name or date inconsistencies before they cause trouble. Employers have a role to play in making the most of these changes. HR teams should audit roles, wages, and job descriptions to ensure that filings accurately reflect duties and market standards. They should budget for filing fees and legal support tied to windows of opportunity when visa numbers become available or when agency guidance authorizes earlier filing of adjustment under Chart B. They should train managers on anti-discrimination rules so workers are not asked for specific documents or treated differently during re-verification. And they should communicate with affected employees early, giving them time to gather documents and schedule medical exams without last-minute panic. Families should also consider financial planning around likely costs. Government fees, medical exams, translations, mailing, and travel add up. Planning these expenses over months rather than days reduces stress and prevents missed windows. If your case involves sponsors, confirm tax transcript availability and address any unusual income patterns. If you expect to move or travel, update addresses promptly and coordinate timing so you do not miss interview letters or request notices. If your family includes members in different countries, build a shared document folder so everyone can upload signed forms or civil documents quickly. As these legislative measures roll out, watch for 3 kinds of official signals that implementation is real. First, agency policy alerts and Federal Register notices will describe how the rule works, who qualifies, and when it starts. Second, operational updates to forms, instructions, or online portals will appear. When a form addition changes or an online checklist adds a new category, the door is opening. Third, you will see effects in public data, visa bulletin notes that reference recaptured numbers, processing times that recalibrate, and NVC queues that shift. Immigration Update Desk will track these signals, compare them with what we see reported by applicants and attorneys nationwide, and translate them into clear steps you can take. The broader significance of 2026's progress is momentum. Once Congress demonstrates that targeted reforms are possible, it becomes easier to advance additional measures. Lawmakers can point to results: shorter lines here, fewer age-outs there, steadier work authorization, and build on what worked. That does not mean the path ahead is simple. Politics will remain contentious, and every change comes with trade-offs. But momentum matters in immigration. And for many families, this is the first year in a long time when the news carries a sense of genuine possibility instead of constant fear. We will continue tracking how each approved bill is implemented, which provisions take effect first, and how they impact real-world processing for green cards and visas. When changes begin to show up in timelines, approvals, and agency guidance, we will break them down clearly so you know exactly what they mean for you and when to act. In the meantime, the smartest approach is to control what you can control. Keep your documents organized, verify your timeline against the Visa Bulletin and USCIS updates, prepare your sponsors, and maintain consistent answers across forms. If an opportunity opens, you will be ready. If it takes longer than expected, you will still be in the best position when it arrives. That's all for this bulletin from Immigration Update Desk. Our channel provides the essential visa information and procedures you need for your U.S. immigration journey. It is important to understand each step clearly: processing stages, application requirements, timelines, forms, fees, interviews, and the practical details that prevent delays, so you can move forward with confidence. We will continue to cover U.S. visitor visas such as B1 and B2, work visas including L1A, L1B, and H1B, student visas, green cards, immigrant categories like EB1, EB2, EB3, EB4, and EB5, and family-based immigrant visas. If you haven't already, please subscribe to Immigration Update Desk and tap the bell so you receive timely, source-backed updates. Thank you for watching. I'm Alex Grant, and we'll see you in the next video where we unpack the latest visa bulletin line by line, show you how to tell whether Chart A or Chart B applies to your case this month, and outline the exact documents you should prepare now so you can move the moment these 2026 provisions are implemented.